Good morning, everyone. Welcome in Brussels in DG Connect. I'm Pierre Marro. I'm working for the Startup Innovation Unit as a team leader for the blockchain file. We are very happy to have such a high number of experts and also colleagues from the Commission services participating in this workshop. A few words about the day. I mean, we will start with some presentation and a panel discussion. And in the afternoon, we'll have more in-depth discussion. I will let our colleague from ConsenSys to explain more about the agenda and the way the day will be conducted. I would like to welcome my colleague Olivier Micol from DG Just that will say some words about the GDPR and where we are now with this, the fact that this major regulation has now entered into force. And as I say already, I'm very pleased also to welcome other colleagues from other Directorate General within the Commission and so many experts in the room. It just shows how it's important that we are engaged in this reflection about how blockchain can be used in the context of GDPR. And I wish you a very fruitful discussion during the day. And I will let my colleague Chiara Mazzone to introduce how we position this workshop within the set of action that we are doing in order to support the uptake of blockchain in Europe as part of our action at Commission level.
Thank you, Pierre. Hello, everybody. Thank you for being here. This is the second workshop of the European Blockchain Observatory and Forum. The first one was held in Vienna a few days ago. It was the 22nd of May, and we kick-started the works of the Blockchain Observatory and Forum, the works offline, because the works online are already well progressing on the thematic blockchain innovation in Europe. So a report has been produced, a very collaborative report, which is currently being discussed and which is up for comments. And this will draw a bit the panorama of what blockchain innovation means in Europe and for Europe. Now we are moving a step forward and we are deep diving into another very timely issue, which is today the blockchains and compatibility with GDPR. We all know that GDPR entered into force, and thanks again for colleagues to take some free time off of their busy schedules to be here with us today. The Observatory and Forum is a process. So it's a process where workshops, so offline discussions will be organized, but it's also a process where online discussions are happening. And if you want, you have three main pillars: the observatory part, the observation part, detect trends, analyze what's happening in that space. You have the discussion part, the debate part that we are here to contribute to today, and you also have the training part, because we realize moving forward with colleagues, with stakeholders, that we need training. So training in different forms, training through exchanges, training through starting from the basics sometimes, and training for most advanced practitioners. We need to know how this decentralized system works, and we need also to understand which benefit they can bring to us, which impact they will have, and how we can take this up for better and more efficient, in our case, public services delivery. Just let me say two introductory words on the day of today. And let me start from a consideration that the consideration is that we are making use of personal data in an unprecedented way and in an unprecedented scale. And the protection of persons in relation to processing of personal data is a fundamental right. Natural persons should have control of their own personal data. And that's not me saying this. I've just taken two recitals from the GDPR. So our question today is how decentralized distributed technologies and models that are claiming that we should restore more rights for the end users, for the data subjects, which would be finally one right of data sovereignty, how they can compose with this and how they can provide solutions to this. So with these few introductory words, let me hand the floor over to the Observatory and Forum, and thanking them for their great work in preparation and that will follow up also this workshop.
Thank you very much, Chiara and Pierre, for these introductions. So just going very briefly to the agenda for the day, just to give you an idea, we are going to discuss in the morning with 2 presentations and the panel discussion. And really the goal of the morning sessions is to identify the main questions and the main issues that we are currently facing when thinking about blockchain and GDPR. This is the main focus of the morning. And then the afternoon sessions, we are going to focus more on the actual solutions. This will be the way we will go forward today. And I will just hand it over to Olivier Micol from GDJust, who will be doing the introduction of the day and sharing with us some insights about GDPR. Thank you.
Thank you very much, and hello to everybody. It's a pleasure for me to be.
There's a question.
Could I first ask the panel to present themselves? Sorry, I'm new. I don't know you.
Okay, I'm going to present myself, but I was on the verge of presenting myself. That's a very good question, a very good start. So my name is Olivier Micol. I'm the head of the data protection unit in DG Justice and Consumer, and my unit is in charge of the application of the GDPR within the European Union. We also have a separate unit dealing with international data flow, so the application of GDPR to international transfers. I don't know if we go through the...
I'm Pierre Marro. I already introduced myself. So I'm the team leader in the Startup Innovation Unit within DG Connect. DG Connect is in charge of the digital single market strategy. And within this unit, we are promoting the exploitation of blockchain as a main technology to innovate and to change things in the digital economy.
My name is Ludovic Courcelas. I work for ConsenSys, who is one of the contractors on the EU Blockchain Observatory and Forum. And I work on these initiatives as project manager along with Ken Timsit on my right.
Good morning. I'm Ken Timsit. I'm a managing director at ConsenSys, responsible for France and a few European countries. And I'm also a contractor to the European Commission for the Observatory and Forum.
Again, Chiara Mazzone, DG Connect, European Commission, working with Pierre on blockchain initiatives at European level.
Good morning. My name is Vitus Ammann. I'm from Switzerland. I'm working with ConsenSys and have the honor to moderate this morning presentations and the panel. I'm teaching and advising on blockchain at the University of Applied Sciences in Lucerne and work for the National Federal Railways in Switzerland, also on projects concerning blockchain and future mobility.
I have another question. You said that it's an open discussion this morning. I was wondering if it's also webcasted or web streamed for those who can't join.
It is recorded. It's not live streamed. It will be, but the video will be published on the website when it's been cleaned up and ready.
Okay, so I think we have done the presentation. As I said, I'm quite pleased to be here today, being invited to this workshop. And indeed, I'm not at all an expert in blockchain, but my role here is basically to give to you some elements about the General Data Protection Regulation, which entered into application some days ago on the 25th of May. As was very rightly recorded a few minutes ago, the right to data protection is a fundamental right. It is enshrined in the Charter of Fundamental Rights and in the Treaty on the Functioning of the European Union. So after these long negotiations about the General Data Protection Regulation, it was adopted in 2016. We had this 2 years transition period between 2016 and May 2018 for stakeholders, for operators to prepare for the entry into application, which is quite rare to give so much time for an EU regulation. So now we have this piece of legislation in place, and it is going to be the regulatory framework for the years to come. And it has required quite a lot of adaptation for some of the operators, and now we need stability. And you have seen the pertinence of this of the GDPR, of course, following the discussion around the Cambridge Analytica and Facebook issues, and now there are new issues popping up. And in fact, the GDPR would have helped us if it had been in place at that time. Would have given us a better tool to address such issue. What is important to stress, and I think this is the one of the commonality between the GDPR and blockchain, is that one of the objective of the GDPR is to give more control over their data to what we call data subjects, so individuals. And this is probably where there is some convergence in terms of objective. What I would like to do very briefly is to highlight some key concepts and principles of the GDPR, which for me have to be taken into account in the reflection on blockchain, to ensure that blockchain will be compliant with the GDPR. Because, as I said, this legal framework is here for the years to come. It has been quite a lot of work to put it in place, a lot of reflection in it. And so now the question today is about its enforcement and application. So to start from the very beginning, I think what is very important is to recall the concept of personal data. And basically, it's everything which is related to an identifier or identifiable persons. And in order to establish this link to a person, account should be taken of all means which are reasonable. So I think it has quite an impact, because when you talk about anonymization, etc., true anonymization means that you cannot, let's say, revert to the individual or establish a link to the individual. It also means that pseudonymized data are personal data and are covered by the GDPR. So only truly anonymous data are outside of the scope of the GDPR. What is also important to consider in this context is that the Court of Justice has always taken a rather broad interpretation of what constitutes personal data. So the case law is supporting a broad interpretation. As I said, only anonymous data fall outside of the scope of the GDPR. So there is irreversible anonymization. And in this context, it's worth looking at what the data protection authorities, and I will explain their role a bit later, have published some years ago in 2014 on anonymization technique. So this is really their position as enforcers of the GDPR now, about what they consider as anonymization. And in this context, they consider hashes as a form of pseudonymization. So basically, they fall under the scope of the GDPR. And it might be that this opinion will have, of course, to be adjusted, because it dates back already to 3 years, and things move quite quickly. What is also very important when we talk about the GDPR is the concept of controllership. because the key feature and the reasoning of the GDPR is based on the issue of the concept of accountability of the controller. So the controller who determines the purposes and the means of the data processing. And this controller and the processor who processes data on the behalf of the controller are really the person responsible, the entity responsible. And you can have joint controllerships if different controller determine the means and purpose of the processing. But this concept of controllership is one key feature of the GDPR. It is a key feature because they are the one to which the data subject or the individuals will turn to in order to exercise their rights and the right to information, the right to rectification, the right of access to one's personal data, the right to erasure, or the right to port, for instance, one's personal data. They are also the ones who are in charge when there is a high risk for individuals to conduct data protection impact assessment. And they are the one as well as there's only some example that in case there is a data breaches, now they have to notify, of course, the data protection authorities, but also the data subject in case these data breaches will entail risk for the data subject, and they have to do so within 72 hours. So this concept is one pillar of the GDPR. Another important element is the data protection by design. So from the start, any tool, any services, any product have to be designed taking into account the data protection, which does not come as a layer on top of a product, but it is embedded in the design of the product. Some principle of data protection, which are also, I think, important to mention, is the concept of data minimization. So only the data which are strictly necessary for one given purpose should be processed, and it leads to the fact that the purposes from the start you have to define the purpose for which the data are processed, and processing means all type of operation on the data. It means the collection, the storage, the use, the deletion, the erasure, everything. So you have to define first really the purpose for which you collect the data. You have to define the storage limitation for how long the data will be stored, and it has to be deleted after this period, and it has to be fixed. To keep the accuracy of the data. So it means that if the data are not correct, then they need to be corrected. And it has to be, of course, stored safely. So you have this basic principle of the data protection, which are not new. In fact, this concept of this principle have been there for the last 20 years in the current legislation. They are more and more taken on board in other countries, and we see that this is also these are principles which are recognized internationally, and which are really the founding basis of the GDPR. And of course, what is very important is when you process data that you establish from the beginning on which legal basis you process this data. It can be the consent. A lot of people are talking a lot about the consent in the GDPR, but you have in total 6 legal bases to process the data. It can be the legitimate interest of the data controller. It can be a legal obligation. It can be a task in the public interest. It can be a contractual taking place in the context of a contract. So you have a number of legal bases. What is very important is at the beginning, when you start processing, before you start processing the data, you know on which legal basis you are processing this data. what is also, I think, important in the context of the blockchain, where you can have data transfer to controllers which are not located in the EU, is to comply with the condition associated to data transfers to third countries. And then you have a number of instruments which are developed in the GDPR, but this concept of data transfer to a third country controller is an important one. And I would also like to mention that it is important to find a way to ensure that data subject and individual can have an effective enforcement of its rights. So it has to be able for the data subject to turn to the data protection authority at national level or to have effective judicial remedy. And then the person against whom you exercise this judicial remedy has to be identified. Now, how does it work in practical terms? You have data protection authorities in every member state. They are the enforcers of the GDPR. They are the ones receiving the member states should equip them with the necessary resources and powers in line with the GDPR. What is extremely important for operators in the EU is that with the establishment of what we call the European Data Protection Board, composed of the 28 national data protection authorities, there is a mechanism to ensure consistency of the application of the GDPR throughout the EU. So there will no longer be 28 interpretation of the legislation. There won't be also for an operator with different operations throughout the EU to have to deal with different data protection authority. They will have one interlocutor, which is normally the places of their main establishment or the data protection authority of the member states where decisions are taken on data protection, so that it will greatly facilitate the life of the operators. And this European Data Protection Board is a body who will issue guidelines, and they have already started to do so in their previous formation, which was called the Article 29 Working Party. There are already extremely useful guidelines on interpreting the concept of the GDPR. You have a concept of what is automatic data processing, what is consent, etc. You have already 10, 11 guidelines, and they are still working on that. These guidelines will bind them in their interpretation of the GDPR. They were all submitted to public consultations. And what is important is that when two data protection authorities will be in disagreement, they will be able to refer this disagreement to the European Data Protection Board, who will take a binding decision. So you will not have a situation where, as a data controller, you are subject to basically two different positions in different member states. There will be a binding decision by the European Data Protection Board. And of course, they have reinforced enforcement powers, and with including fines, which could be up to 4% of the global turnover, worldwide turnover, or 20 million euros, whichever is higher. So I would say that it is very important that as an industry, as let's say a practitioner, it is important to be in touch with the data protection authorities at national level and to be in touch also with the European Data Protection Board, because they are the one in charge of informing, they are the one in charge of discussing with the operators, with the individuals, and if they deem it necessary to come with an opinion on how they interpret a certain concept. For instance, I mentioned the opinion on anonymization, etc. But there is a wide array of such opinion which can be updated. So I will stop here, but I wanted to give you this element. I hope I was not too long. Thank you.
Thank you very much, Olivier, for this introduction. I think being in touch is exactly the theme of today, and we are very happy that you brought us the direct information from DG Just. I would like to proceed with the first presentation, which will provide some first insights and the overview. Okay. Some first burning questions.
Yeah, sorry. Very quick. It's for my own understanding. So we agree that there's a potential fine of 4% of the overall turnover for a private company in case of issue with GDPR and compliance. What about public administration? If there's also an issue with them, how does it work? Thank you.
So for public administration, there is a flexibility given to member states. They can decide to apply fines, to give the power to their National Data Protection Authority to fine public administration. A number of member states have decided to do so. Some have decided not to do so. But in any case, what is important is that even if they decide not to have this fining system for their public administration, they should ensure that the Data Protection Authority has an effective powers so that these other sanctions are in fact deterrent and effective enough. Just for the record, because we have also a regulation applying to EU institutions and bodies, we have decided to give to all supervisory authorities, the European Data Protection Supervisor, the power to fine EU institutions and bodies. So when we proposed that to our colleagues, not everybody was extremely happy, but we thought we should lead by example so that all supervisory authority has the power to impose fines on the Commission, on the Council, or any of the 64 EU institutions and bodies.
Thank you. Sorin Crisescu from the Commission, the DG Digit. Did I understand well that the opinions of the Article 29 working group are going to be binding on the interpretations in court of the GDPR?
Thank you. No, what I said is that the opinion of and the guidelines that the Article 29 Working Party now, which is becoming now the European Data Protection Board from the 25th of May, will bind their interpretation as enforcers. So, but it means that when the data protection authorities will go, we will look at a processing operation, for instance, I don't know, the concept of consent. They have agreed, the 28 of them, that consent should be interpreted this way. And you have the guidelines of consent. So this will guide them in their work as enforcers. Then, of course, it might be possible for a data subject or a company to go to the national court and contest the decision of the data protection authorities. But it gives a legal certainty to the operators because you, as either as a controller or as an individual, you know that the enforcers will interpret consent in this way, and they are very detailed consent. They are very detailed guidelines. So with a lot of examples. So the objective is to help to give more legal certainty on key concept. Thank you.
Excuse me, a quick follow-up. What are the means to, this is a huge power that is put into the Article 29 working group. What are the means to influence their opinions? Shouldn't there be some kind of democratic oversight over what they decide, whatever they decide to interpret has a big impact, and yeah, so shouldn't there be a democratic oversight over what they decide?
This is the same with all regulators, enforcers. I mean, if you contest their decision, then you can go, you can challenge this decision what is important in the context of the Data Protection Authority, the European Data Protection Board, is that they have this unified interpretation. This is designed to help the data controller and the data subjects, so all the operators in the EU. They are consulting when they adopt their guidelines. We have a lot of replies when they basically issue their draft guidelines. They have the freedom to take on board the comments or not, because at the end of the day, they are independent authorities. This is a very important point. In national level, they are independent authorities. They cannot receive instruction from anybody. And then, of course, if you contest their decision, you go to court.
Okay, thank you very much. I would like now to move further to the blockchain, and with the first insights by a senior research fellow at the Max Planck Institute, lecturer in law at the Cable College in University of Oxford. She teaches and advises on the intersection of tech and law, so is best equipped to bring us closer to today's topics. Please give a warm welcome to Michèle Finck.
Hi everyone, good morning. So today we have a really diverse group of people in the room, which I think is great. So we have people who know a lot about blockchain, maybe a bit less about the GDPR. We have people who know a lot about the GDPR, who are even among the many mothers and fathers of the GDPR, but who might not be expert in blockchain. And my role today is really to bring everyone, get everyone on the same page and create a sort of common understanding of what the main points of interaction between the legal framework on the one hand and the technology on the other are. And I'll try to do so in a number of different steps. So I'll first provide a really very, very brief introduction of what I think the main elements of both the GDPR and blockchains are for today's discussion. I'll then talk about the many points of tension that we can identify when looking at how we can apply the GDPR to blockchains. And I'll conclude by offering two different outlooks, one of a pessimistic and one of an optimistic nature, that should then give us enough to talk about for the rest of today's session.
Can everyone hear?
Good question. Yes? Should I speak up?
Yeah,
okay, I'll speak up. I think
It's already on.
it was already on. Okay, I'll scream. Great. So the GDPR, I think I don't really need to say much about this. Olivier Micol has provided an excellent introduction into the main components of the scheme as such. I think one thing I maybe want to briefly recall is that the GDPR pursues a dual objective, which is something that's often not sort of acknowledged. Firstly, it aims to facilitate the free movement of personal data between the various member states of the European Union. And secondly, it pursues the fundamental rights protection objective. So it gives expression to the right to data protection that we find in the Charter of Fundamental Rights. And this includes giving data subjects more control over their personal data, which is a point that I think is particularly relevant when we look at this from the blockchain perspective. And I'll come back to this towards the very end of my presentation. One thing I'll say about the GDPR is that the GDPR was fashioned with a specific assumption of what a database is in mind. This isn't explicit in the text, but I do think that it's implicit in its scheme. So there's this presumption that a database is something where data is centrally collected, centrally stored, and also centrally processed. And of course, this is something that we find in many circumstances, even though maybe not technically, but definitely from a legal perspective. Right, so if you think about something like the GAFA platforms, this is definitely how, at least legally, we can make sense of data processing in this context. Now, blockchains decentralize all of those processes, or at least promise to decentralize all of those processes. So we have decentralized collection, storage, and processing of personal data, at least on public and permissionless blockchains. So So data is decentrally collected to the extent that, at least on the public and permissionless blockchain, everyone can, if they want to and know how to, add data to the ledger. There's also decentralized processing to the extent that transactions are processed by the various miners or validators, whatever we want to call them, depending on the ConsenSys protocol that's being used. And I, as a data subject, don't have control over which miner, node, or validator will process my data. And then there's also decentralized storage. So at least in principle, on the blockchain, every full node will store a full copy of all of the data that's being put into it. And when we look at the big public and permissionless blockchains, at least, such as Bitcoin or Ethereum, this varies over time, but there's typically between 10 and 20,000 nodes that store full copies of this ledger that are located in various jurisdictions around the world. So I think the first point to really note when trying to understand why so many people are talking about this conflict between the GDPR and blockchains is that the underlying assumption of what a database is varies. With respect to GDPR, there's this assumption that there's this element of decentralization, whereas what blockchains really try to do is decentralize all of those elements. Now, the next question must, of course, be, does the GDPR apply to blockchains? And in order to determine whether the GDPR applies in a given context, we need to identify whether there is personal data. So the GDPR applies whenever you process personal data, no matter what technology is used. And this element of technological neutrality is something that's really prominent in the GDPR context, and it's also something that's explicitly mentioned in its preamble. Now, the GDPR defines personal data as any information relating to an identified or identifiable natural person, which is referred to as the data subject. And Olivier Micol has already said it, the definition, the interpretation of this phrase is done in a very broad way. So there's a very broad and inclusive concept of what personal data is under the GDPR. If you have personal data, if you have data that relates to an identified or identifiable natural person, the only way to evade the scope of application of the GDPR is to anonymize that data. And the anonymization only arises where you irreversibly prevent identification. So you can see that there's a very high threshold as to when anonymization actually occurs. And importantly, pseudonymizing your data doesn't allow you to reach that threshold. And again, this is something that has been said in the introduction, but I think it's worth repeating again. Pseudonymous data remains personal data under the GDPR. So where you do something, you apply a pseudonymization technique, you do not avoid the GDPR scope, which is an element that's often misunderstood, but really, really crucial. Now, what do we have on the blockchain that might qualify as personal data? I think there's two broad categories, and obviously there's variance, but I think we can sort of group data that might be personal data on the blockchain in two different groups. First of all, there's transactional data. It's a term I use that might not be perfect, but it basically refers to both data related to transactions themselves on the blockchains, but also anything else you might put on there. So it might be messages. If I decide to write a poem that's really revealing of my personal life and put it on the blockchain or hash it to the blockchain, that would also be personal data that falls into that category that would then be on the blockchain. And again, this is an issue where there's lots of misunderstandings and also debates. There's also public keys. At least I think that public keys do constitute personal data from a GDPR perspective. So they're personal identifiers that are put on the blockchain. And if you link public keys, even though they're pseudonymous information, if you link public keys with additional identifiers, you can identify a person. So you haven't irreversibly prevented identification, and thus no anonymization has been achieved. Now, there's three different ways in which this data, which might constitute personal data, can be added to a blockchain. And again, I think this is something I want to emphasize because often there's this perception that because you cryptographically modify at least some of the data that exists on the blockchain, the GDPR doesn't apply. This is not true. So when we look at the three different options, we first have the possibility to store data on the blockchain in plain text. This, of course, isn't often done. It's impractical, it's expensive, and thus rare. Where you do that, so where I take my poem that's really revealing of some personal stuff and put it on the blockchain, of course, I don't modify it, so it is personal data. It remains personal data even where it is on the blockchain. The same applies where I use encryption. So the Article 29 Working Party stated in its opinion 5/2014 that encryption is not a method of anonymization. It merely serves to pseudonymize personal data. So even where I take data that is personal data at its origin, put it on the blockchain using encryption, it remains personal data, and thus the GDPR continues to apply. Secondly, the same can be said in relation to hashing. So even where I take something that is personal data at its origin, put it on the blockchain through a hashing process, this still most likely remains personal data for the purposes of the GDPR. And again, this goes back to the Article 29 Working Party's guidance in Opinion 5/2014. So from that, we can see that there should at least be a presumption that whenever you have personal data and you put it on the blockchain, it remains personal data. And as a consequence, the GDPR applies to whatever you're doing. Now, the next question is then, of course, what are the consequences of this? What are the consequences of having the GDPR apply to your specific project? And there's many, many different things that follow from that. And I really don't have time to go into all of them. I think we'll do so more throughout the day. But I just want to single out a few that I think are particularly interested in this context. So first of all, the question becomes, who is the data controller? Once you've determined that the GDPR applies, you need to ask the question, well, who's actually in charge with complying with the various obligations that the GDPR sets out? GDPR says the data controller is the entity that's in charge of determining the means and purposes of data processing. And there's a lot of uncertainty as to what that entity is in a blockchain context. And I think that when having this discussion, it's really important to distinguish between what layer of the blockchain ecosystem you're actually talking about. So I think there's an argument to be made that when you're at the application layer, there's an argument to be made that it's actually the application or the legal entity behind the application as such that qualifies as the data controller. Where you're at the infrastructure level, things get a bit more complicated. So in the context of a public, private, and permissioned blockchain, you might argue that, so for instance, when you have the state outsourcing blockchain-based land registry or whatever, there's an argument to be made that the state is the data controller and the actual entity behind the technical infrastructure is merely a processor. But when you're looking at public and permissionless blockchains, it gets really complicated. And I think the most convincing argument to be made in this regard is that it is nodes that are data controllers. And that's, of course, difficult because there's many of them, they're hard to identify, and also they're unable to comply with the GDPR substantive provisions in most cases. Another consequence of finding that the GDPR applies to the specific blockchain or blockchain-based application is that the prohibition of extra union processing of personal data applies. So the GDPR says that you can't transfer personal data to third countries unless those countries offer an equivalent level of protection. Few countries have been recognized to offer an equivalent level of protection. So again, imagine you're in the context of a public and permissionless blockchain. Even though I might be based in Europe, put my data on the blockchain here, I have no control over where in the world it goes afterwards. And there's nodes in so many jurisdictions that will not be compliant with that. So we, again, have an important point of tension there. Then there's the GDPR's obligation of data minimization. Data minimization is one of the key principles of the GDPR set out in Article 5. It requires you to only ever process as much data as you absolutely need to fulfill a specific objective. Blockchains are an ever-growing append-only ledger in which data perpetually increases, right? So very hard to see how you can reconcile those two elements. GDPR also creates a right to amendment of personal data in Article 16. Blockchains are designed to be tamper-proof ledgers on which information can only be removed or changed in extraordinary circumstances. So again, lots of uncertainty as to how you might comply with this. Then the GDPR also codifies the right to erasure. This is what's often referred to as the right to be forgotten. And of course, there's the same problem. If blockchains are tamper-proof or tamper-evident databases, then it's very difficult to see how you can actually comply with this duty to erase data in this context. And then there's something that hasn't been talked about that much yet, but which I think might also be an interesting point of discussion for today. There's also a provision in the GDPR, Article 22, which gives data subjects the right to be protected from automated processing. So you cannot be subject to the decision, to a decision reached by automated data processing in some circumstances. It's not a sort of unlimited right, where this has legal or otherwise substantive effects on you. And the question from the blockchain perspective is, of course, well, what about smart contracts? Smart contracts actually essentially are a form of automated data processing, and how can we reconcile this with Article 22? So what we can see from this is that there's many points of tension between this legal framework that was created for under the assumption that data is sort of centrally collected, stored, and processed, and blockchains that promise and to decentralize all of these processes. Now, from that, we can reach two conclusions, a pessimistic one and an optimistic one. And I'll start with the pessimistic one because I want to end on an optimistic note. So when we look at this, we see that there's lots of tension between the legal framework and the technology. There's many uncertainties. So for instance, we simply don't know who's subject to GDPR obligations. People that want to build something in this context find it hard to determine who actually needs to comply with them and how they can comply with them. So we don't know how many of the data subject's substantive rights can be implemented in the blockchain context, such as, for instance, the right to erasure. Looking at the tension between blockchains and the GDPR also revealed some broader issues with the GDPR as such in any context. So, for instance, there is still a lot of terminological difficulty or uncertainty in relation to GDPR. For instance, we don't know what erasure means. Different cases of the European Court of Justice have interpreted this in a different way. The GDPR itself doesn't define it. And of course, this is really crucial if you want to know what you're actually required to do with data, where the data subject invokes Article 17. There's also technological uncertainty to the extent that the Article 29 Working Party has indicated that while hashing is in most cases at least only a technique of pseudonymization, it's not entirely clear whether it can never be a technique of anonymization, and if so, in what circumstances, what needs to be done. And from that, I think it's fair to say that many, if not most, blockchain projects that we currently have are likely not compatible with the GDPR. And then if we conclude that, I think there's two broader questions we need to ask. So first of all, many people are arguing that, well, if we have those tensions, then maybe we should just shouldn't have blockchains because they're bad for data protection. This is what Jan-Peter Albrecht, who's one of the sort of prominent figures in the history of the GDPR, has argued. And then, of course, people more on the industry side are arguing that they are finding it very, very hard to build things because they simply don't know how they can build them in a GDPR compliant way. And from that, we might have to worry that this lack of legal certainty that currently doubtlessly exists is actually bad for innovation in Europe and bad for establishing Europe as an important player in the maybe forthcoming blockchain industry. Now, I don't want to end on this pessimistic note. I'm an optimist, so I'm also going to offer some maybe more cheerful things to say about this tension, and maybe also some points that we should focus on in discussions today. So I think, first of all, it's important to go back to what I said at the very beginning. So one of the objectives of the GDPR is to protect the fundamental right to data protection, and that includes giving data subjects more control over their personal data. I think one of the things that's very interesting when we look at many, definitely not all, but many projects that are currently going on in relation to blockchain and blockchain-based implications is that there are many projects that pursue the exact same objective, right? So blockchains might be a tool of achieving this goal of data sovereignty, which is also one of the goals of the GDPR. I think it's also worth stressing that blockchains are, as of yet, still an immature technology, and an immature technology is a malleable technology, right? So we know that the technology itself will need to develop in many ways to be able to be used in the way that people hope it will be used in the future. And you can look at this as an opportunity, right? You can say that because technology needs to change itself, because it can still change relatively easily, well, let's try to do the required modification in a way that ensure GDPR compliance. And this actually leads into a goal that's also shared by the relevant European institutions, such as, for instance, the European Data Protection Supervisor, who issued an opinion on this, I think exactly a week ago, of saying that maybe we should look at new technologies. Yes, definitely they can be a threat to data protection, but they can also be an opportunity for data protection. And maybe we should think about how we can use blockchains in a way that achieves the goals inherent to the GDPR. One development that's worth mentioning in this regard is that many people are thinking of achieving data protection by design, which is enshrined in Article 25 of the GDPR, by using blockchains. And there's also many people who are saying that blockchains are a uniquely positive technology from the perspective of them being able to combine privacy and transparency where they're adequately sort of designed. Now, how do we get there? I think what's needed to make blockchains and the GDPR compatible is collaboration, discussion, and understanding between various stakeholders, and that's why I'm so excited for today. And this is also where I'll stop, and I'm looking forward to the discussions afterwards.
Well, Michèle, thank you so much for this very concise introduction into the topic. Are there currently any burning questions which cannot wait to the panel discussion? Can wait. So we can... Yeah.
Hi.
So welcome to Brussels, and I wanted to ask you about this.
Excuse me, could you start questions with your name, or country, and organization?
I was getting there. Hi, Micol, I work for DG ENER, European Commission. You mentioned the stakeholder collaboration and the techno-legal interoperability. And of course, the revision of the GDPR is not likely. We all know how long does it take to review a piece of legislation. So the question is, what level of governance you would see as a right vehicle for assuring this kind of interoperability?
Yeah, I mean, I would never suggest that the way to sort of solve the points of tension that I highlighted is changing the GDPR, because we know it won't happen, and it might also not be necessary, right? There's other things that can happen. So first of all, hopefully there will be guidance by the relevant European institutions at some point on this. And then secondly, you might also get stakeholders or industry organizations to think about codes of conduct or standards in this area. And I think that doing those two things might be enough in at least many contexts, because largely the problems we've identified are not so much about sort of the wording of the GDPR itself, but rather about how it is to be interpreted, or uncertainty as to how certain specific provisions or certain obligations can be complied with in the blockchain context. So you don't necessarily need to change legislation to make both work in harmony. You just need to know sort of what So I think it might be possible to sort of like do that within the framework that we have, but there needs to be clearer guidance and a clearer understanding of both the technology and the law on both sides.
Thank you so much. Our second speaker of today. You lowered your hands when I was asking of our panel, but please feel free.
Yeah, well, I very much appreciated this introduction by Michèle Finck. Thank you so much. It was very clear in highlighting the burning points.
Can you quickly say who you are?
I'm Mori Fletcher from Linkaeus, Italy.
Thank you.
Running one project which is called My Health, My Data. So I'm very much interested in these issues. And so one point is, you mentioned the blockchain in general. There is the possibility of having off-chain storage of the data, of the personal data, and using the blockchain just for the transactions. You mentioned the transactional data. This is possibly a point which needs more clarification. And the other thing is that as a principle, when you say there is a conflict between the idea of the blockchain as non-temporable, immutable, and the fact that there is the right to be forgotten, one can think of a solution by which the transaction regarding the data is always in the blockchain. But the capacity of going back from the transaction to re-identify the data subject, this can be broken because the key can be just destroyed. So this would be touching this principal point. So I just wanted to point this out.
Do you have a question?
Is that a sufficient element or not?
Do you have a question?
Can I just reply?
Okay. Okay.
Can I reply to that?
Sorry.
I think we will come back exactly to that question in the panel, actually.
Okay.
Okay. I assume that we can answer your questions also in the panel because I need to look a little bit at the time. So no offense, but I see that as a high interest in the audience. Because I want to introduce our second speaker. He has done actually GDPR and blockchain, a very exciting project. And he and his innovative team have achieved what many thought was impossible. So maybe he's already answering some of your questions. Let's hear now how he managed to marry the concepts of GDPR and blockchain. Please welcome Alexis Bertolli on stage.
Hello, good morning, everybody. Can you hear me correctly? Okay. Good morning. So, well, I first want to thank you, Ludovic, for this invitation to this workshop. I come from Paris, and I will introduce you the solution we are developing, and we are setting up in production within 2 months now. And, well, the first part will be the description, a first quick description of our solution. And the second part may be the approach we had to comply with the GDPR regarding our own solution. So a few words about the project. We come with the 2 other founders of the company from the educational sector. So we know quite well these activities. And we observed 2 things important that helped us to have this idea to build this project. First, institutions have the obligation to conserve degrees over 50 years. Second fact is that current solution to store degrees, to store certificates, is quite complicated today. It is mainly based on centralized servers. It's hard to maintain over the time. It has a cost. If you work with a provider, you don't have the certitude that the provider will exist within 5 or 10 years. So that was a problem. Our CTO is a founder of blockchain technology since the very beginning of this technology. So he had a simple idea based on, publishing the degrees on the blockchain and giving the possibility to respect the GDPR, in particular, the right to be forgotten. I'm going to try to explain you how we implemented that. Just a few words about the state of play of the company. So the first release of the application will be ready in August or September of this year. We have a few famous advisors following us and supporting the project. It's the same thing. We have some very interesting partnerships with innovating poles in France, the BPI. We integrated Station F, the famous startup incubator in Paris 2 months ago. And we have yet our first customers, even if the solution is not ready yet. Yes? People are having trouble hearing you in the back. Okay, let's try to do that. So let me try to explain really quickly how does the solution work. We will sell our solution to institutions issuing degrees. And that's a really important point regarding the trust in the solution, is that we will give a certificate and we will give access to our application to higher education institution after verification that they are real institutions. That's really the key point and the very beginning point of the solution. Once an institution has access to our solution, it's a web application you can access through any browser, and very easily through an Excel file or CSV file, they can upload and publish degrees on the blockchain. For each degree issued and certified on the blockchain, we will provide the institution and at the end the graduate a URL or a QR code. And thanks to this QR code, the recruiter or any person who has this link will be able to, by a single click, to check the authenticity of the diploma. So very quickly, here is an example of what you can have as information when you click on a link. So this is a really nice looking template certifying the degree has been obtained. So this page will probably display on the school domain name. And we have 2 more layers indicating and giving more detail about this certification. We give the school the possibility to customize his template to be close or not close to his paper document if he thinks it's important to respect visual. But we also wanted to indicate very clearly what are the data certified on the blockchain. So we'll have 2 types of data, the issuer indicating who issued and certified the data, and the very precise content of what has been published on the blockchain. So here you have an example with Miss Clarence Wright from Liston University. And the last layer of checking regarding the blockchain proofs would be to indicate here the name of the university, some legal references, and one important thing would be to indicate the public address of the issuer, allowing the person who wants to double check the authenticity of this degree to check this address and to compare this public address that could be displayed, for instance, on an institutional page of the school's website. Okay, so now let me try to explain what has been our initial choices and how do we implemented these choices respecting the regulation. So we made the strong choice to use a public blockchain to store the degrees. I won't give you a course about blockchain. I assume you get it. But mainly, we use Ethereum blockchain thanks to its smart contracts. It allows to process trusted operation without third party, and that's really important in our activity. The second strong choice we did, and that's strong specificity, and we are really liking this specificity, making our project quite unique among all the emerging certification projects, is that we decided to store the encrypted data directly on the blockchain. So this has several consequences, but one of the main one is that we avoid to store the degree or the data of the degree in a centralized server. So we avoid any risk of corruption of the data, falsification, steal of the data, etc., etc. As Michèle explained during her speech, it's important to talk about the nature of the data. So as you may understand now, we will publish and certify only the very important and the little data of each degree. So basically, it will be the first name, the last name, some information regarding the graduate, and the degree, the mention, the grade, the pass, eventually, etc., etc. What is the objective, the purpose of this data processing? We want to give the student the possibility to share his authenticated degree. And maybe one more interesting information is that the data processing responsible will be the issuer. So it will be the school that will issue the degree. So this is an important point here this morning. Okay, we had decided to use the blockchain to certify degrees, and we wanted at first to store the data on the blockchain. So we understood really quickly that this would be, really closely looked by the regulators. You have to know that at the very beginning of the project, from the very early stage, as soon as we had defined the specification of the solution, we went to our lawyer firm office, we closed the door, and we worked with our lawyer during 2 months just to ensure with him that the solution would be RGPD, GDPR compliant. So it's really important because we start the activity right now, and of course we can't pass by all this regulation. Mainly, what has been the concrete point that helped Alain Bensoucian, our lawyer from Lexing law firm, to give us a positive legal opinion regarding our project. The key point is that we created a data encryption technique that he thinks, and we think, give a reasonable and proportionate answer to current regulation. In particular, the right to be forgotten. So let me try to explain you how does it work. First, we use the highest standard encryption system we can find today, AES 256 encryption technique. And based on this encryption technique, we build a very complicated algorithm just to ensure that the data will be super well crypted. As a result of this encryption, we have 3 different keys that will be mandatory to decrypt the degree. The first key, well, 2 keys will be stored in secured vaults by the school. First one is a master key. So each issuer, each school has 1 master key and will also store in HSM the diploma persistent key. So 1 persistent key by degree. The third key belongs to the URL, to the link, to the QR code we will provide to the student who own his degree. So it's really important to understand that without these 3 keys, it will be absolutely impossible to decrypt and to read the encrypted degree on the blockchain. So once again, I insist on the fact that the algorithm we use is really respecting the highest standards. For instance, it's the algorithm used by the NSA, the defense, army, etc., etc. Okay, so how we implemented these concepts, these regulation concepts to be mandatory to GDPR? First, as a provider, we have the obligation to train and to explain the users, and mainly the first users that are the institution, that it's important to have the consent of the student and to inform him that his degree will be published and stored on the blockchain. We implemented the possibility for the student to share his degree and to destroy the possibility to read his degree. Because from the previous slide, with our 3 key system, if the student wants to use of his right to be forgotten regarding his degree, he just has to contact the school and ask the school to delete his persistent key, his degree persistent key. Once the persistent key is deleted, the degree will be unreadable forever. Another important point is that the student has the possibility to share or not to share this link, and without this link containing one of the 3 keys, it will be absolutely impossible to read the degree. Thanks to this 3 key system, it's impossible also to recover and to exploit the data on the blockchain. So that this highest standard security algorithm that allow us to say that we think being GDPR compliant. So we are deeply conscious, and that's the topic of this meeting, that there's this collision course between the GDPR and the blockchain technology. We at BCDiploma try to bring a pragmatic but humble solution to that problem. We defend strong values such as innovation. I think innovation is also important for the European Commission. We give also the control of his own data to the owner of the data subject. as he can share and decide not to share this link. He can use to his right to be forgotten. And once again, we face to the current solution, technological solutions we have, face to the risk to hack and to break the code and the algorithm. We think we implemented a reasonable solution proportionate to the project we had. Thanks a lot, everybody.
Thank you very much, Alexis, for this inspiring presentation. I think, although humble, you made quite some strong statements.
Thank you.
Any questions for clarification right now? Yes.
Good morning, Jean-Marie Mistela, representing DG Santé, Health and Food Safety. I have a question about the volumes you have. How many diplomas you have issued, since when? How many steps in the blockchain, and do you have any performance issues?
Very nice question. Unfortunately, actually, currently we have issued 0 degrees because the solution is under development. The first version will be released this summer. We are working on the test Ethereum blockchain currently, and the tests are really positive. From our provider, we work with a Thallium company specialized in blockchain technology. And the first feedback are quite positive regarding performance topics.
Okay. On the design, how many steps do you... I don't understand the number of steps you have in the blockchain. And what is the blockchain added value in that?
The blockchain is the sustainability of the data, the accessibility of the data. We avoid any centralized storage. So that's mainly the objectives we want to reach.
Okay, it is the storage. Thank you.
Yes.
Hi, Joshua Hawthorne Mandel, Data Wallet, US and Berlin company. That was a very elegant solution that you proposed. I'm curious though, the deletion of a key, the data is still there, although in an unreadable format. I mean, how did you and your legal team kind of come to the conclusion that that satisfies erasure, as you know, given enough computational power and time, and depending on kind of advancements in technology, that's not actually destroying any information?
We totally agree. So, well, in my opinion, this topic is not really a technical topic. It's a more theoretical topic and a lawyer's topic. Because I totally agree with you that the data, the encrypted data, will remain on the blockchain forever. But thanks to that encryption system and this 3 encryption key system, we consider that this data will be unreadable forever. That's a point of view, and we believe in that point of view.
Yeah, that's very reasonable. Thank you. I mean, it's just, yeah, that's what we're here to discuss, kind of.
Yeah, for sure.
Hello, I'm a data scientist, and I'm currently employed with the European Data Protection Supervisor. I have a technical question. For my feeling, I have the impression that your system does not offer so much more than what you can do with ordinary digital signatures without the blockchain. And I would like to know specifically how you address the issue that an institution could lose its own key. If it comes out, for instance, that an institution has lost its key and that anyone could principally issue such a diploma, wouldn't this also remove the authenticity of all diplomas that have been issued before? How you address these concerns?
It's an interesting concern. Well, the answer and the solution we offer to that scenario is to store the data, because we start the activity in a SaaS mode. Okay, so we offer the deployment of the framework for the institution, okay? And we manage the storage of the keys. And the answer to that question is that we will store the keys, the school keys, in the top-level securities vaults, such as HSM. And that's basically the answer we have. And we are setting up also, after discussing with some current contact, we are working on specifying some backup systems for these keys. But at this point, we also have to consider that we provide a solution. I forgot to tell you that during my speech that our solution is based on an open source framework. So schools will be able, if they have some resources, to implement by their own the solution. But at the moment, we have also to consider who is responsible of what. And well, the solution we offer make the institution responsible for his keys, her keys, okay? It's, on my side, more or less the same problem that today. If the server where a school stores all the PDF documents burnt or is hacked, we are exactly in the same situation.
I mean, of course, people can lose their keys. I mean, I also have passwords, but if people have access to this password, they have the data that is only on my computer. And this data can still potentially be deleted, but if it is in a global database shared by millions of peers in the internet, I do not see how you can easily manage this data breach afterwards. But I suggest that we go further than with other questions. I don't want to monopolize the discussion.
Thank you.
Thank you.
Yep.
Just one stupid question for the end, but I want to keep my question for Dr. Finck for the panel. To be more specific, so I'm Digit, I'm Blockchain Competence Center leader, so I'm a technologist. Who pays the transaction fees on Ethereum?
Good question. Yes, just to make things quick, I didn't talk about this topic, but the business model is super simple. As we are going to ask to pay the institution we issue degrees. So it's a unique price. If you, let's say, we plan to offer a price between 2 and 4 euro per diploma issued. So if you issued 10 diplomas, you'll have to pay 20 euros, let's say. And that's the only cost of the solution, because after that, thanks to the link the graduate has, you can click on this link with no time limit and with no number of click limit. It will be free for everybody and for any time.
Okay. Thank you very much, Alexis, for this question. Thank you very much for the interesting questions. I would now propose that we have a 5-minute break to set up for the panel and ask my esteemed colleagues to make place for Elisabeth, Jörn, Michèle, and Alexis to join me here on the podium. Thank you so much.